Ladies and gentlemen and ladies and gents, we are going to be talking just briefly for a moment. It is absolutely, positively, doodly necessary that we have this conversation. Why? Because I am still working on, and as you've paid attention, those of you who have, to the judicial criminal misconduct complaint form that I am putting together that is going to operate as a template for others, that it has taken me a while. Why? Because putting together a document, putting together any legal document or any contract is not a matter of just throwing a bunch of words on a piece of paper. There is a format, there is a structure, there is a cohesiveness that must be associated. I'm sorry, give me a second because I am going to have music in my background for this. I'm working on my phablet. A phablet? What the is a phablet? A phablet is a tablet that has the ability of making calls without Wi-Fi because it has a SIM card slot where you put a SIM card in and you say, "Hey, Johnny, how you doing? Alexa." Anyway, that's what's going on, ladies and gentlemen. Now, what I'm about to do is like I said, I'm about to play my music, and we got the Jackson's 2300 Jackson Street. This is Play It Up, but it's the same beat for 2300 Jackson Street. I don't think people recognize that, but they did because it's the Jacksons. All right. They're going to be in our background a little bit, and then we're going to get on to something else. I got to show you guys something. Okay, get rid of that. I don't need that. We're going to go here. Ladies and gentlemen, here's a paragraph that I'm working on, and you guys, I have my phablet. It's attached to a phablet holder, but this holder bounces, so I am now messing with it as it bounces, so y'all just have to excuse me as I make the adjustment so that the light reflection on the screen doesn't mess up. Again, remember your motions. When you do motions, this is not a motion. This is an affidavit. I'll show you the language at the beginning, and eventually I'll do a video on the whole thing, every single aspect of it, why we left certain things in, why we took certain things out. Remember, this is not the final draft. Okay, this is me putting the document together. And we've had some issues, but don't worry about it. Let me go ahead and show you number 4. I am aware, as it is my belief, nobody can fault you for your belief. Remember, you have the right to practice your religion. Religion is based on belief. Nobody can fault you for your belief in America. Now, the true God can fault you, but nobody in America can fault you. That a judicial officer is to remain in office so long as they remain in good standing and practice no bad conduct and or commit a felony, which is a high crime. Pay attention to this, for it is higher than a misdemeanor and or one of the higher. It's not supposed to be that higher. Supposed to be that higher. Gotta go higher. Okay? Higher misdemeanors. Under the high crimes and misdemeanors. Now pay attention. The courts have said Congress has never defined high crimes and misdemeanors, so we don't know what a high crime and misdemeanor is. That's a lie. Ladies and gentlemen, they have defined it when they came up with Title 18. Go back and take a look. When they came up with Title 18, they made a distinction between a misdemeanor and a felony, which are crimes. Go ahead. Don't take my word for it. Go back and do the logic. They've been playing this word game for years, but I'm sorry. I can play the same word game that they play. As a matter of fact, let me get rid of the... I think it'll let me get rid of it. Okay. Ladies and gentlemen, I did it again. Well, we're going to have it on the screen because I don't feel like getting rid of it like that. Ladies and gentlemen, let me break it down to you because everybody and their grandmama know that if you sit up there and you take a candy bar from a store it's a misdemeanor. You get a traffic ticket for driving without a license and you didn't commit any other major crime, it's a misdemeanor. But if you drive without a license and then you run and you hit somebody and you kill them and you ain't got no insurance, oh, surely you're going to be misdemeanors and higher crime felony. It's called high crimes. Ladies and gentlemen, we know that there is a low crime that's called a misdemeanor. We know that a high crime is called a felony. If you don't believe me, go look at Title 18, saying they ain't never defined what a high crime is. Of course they have. But courts have been using this, they ain't never defined it, so that they can get away with junk. Go ahead, just think about it. Every single state has a misdemeanor and a felony, and whenever they put people in jail, because I've had conversations with people about this, I've had to tell them no, because it's this and that. That's why they're charging you with a felony. Okay, a felony is a higher crime than a misdemeanor, because some misdemeanors are punishable by imprisonment or jail time. Sorry, I said the wrong word. Jail time. And some misdemeanors are not. It really, really, really is just that simple, people. And the problem is, I want y'all to focus with me, run with me. The problem is, we've let the courts tell us that they get to interpret law. Do you guys know that ignorance of law is inexcusable? Hold on. Because every time we look up, the courts are telling us. So let me go ahead and we're gonna go 2 paragraphs up. We're gonna be right here. I have disaffirmed any and all contracts associated with infancy, or that I did not knowingly and intentionally consent to engage in such an agreement with full knowledge of the facts and with the ability to opt out of such an agreement after notification of such I'm sorry, I gotta redo that, because notification of such a opt out. Oh, that's what it is. It's supposed to be opt out. Sorry about that. That's voice recognition, y'all. Y'all know how these voice recognition things work. Okay. Oba P mama T mama. O mama, you mama, T mama. There we go. Opt out, period. Okay, that's what it is. Now, ladies and gentlemen, the next one is, it is believed that the judicial officers of the United States that sit and or occupy an office and or capacity as such within the district sit under the authority of the judicial branch of government. Presumably, and it is further believed that while acting under the color of law, they are acting under their oath of office for which they were appointed via a constitutional process, which makes them liable under the limitations established within the Bill of Rights of the Constitution of the United States associated with the oath of office of their oath of their respective offices. Basically, what this is saying, hey, you a judge. When you sat up there and took that office, you did so under the district, right? And when you took that oath of office specifically reflected the Constitution, that you will uphold the Constitution. Well, don't the Constitution say Congress shall make no law? So if Congress can't make no law, the judges can't make a law either, because it's all equal protection. Congress can't make a law, you can't make a law either, or rule or an ordinance or an order. Well, ladies and gentlemen, the judges, when they take oath, they're bound by their oath of office. Their oath of office is to the Constitution. The Constitution has several what is the word I'm looking for? Prohibitions, limitations. So now we're going to do 2 more, and then we're going to go ahead and conclude this video so I can finish this. Like I said, this is taking a while because there is, and then I'm going to trim it down. Right now, I think it's like 15, 16, 17 pages. I want it to be less. Uh-oh. We got R. Kelly. Yo, what up, R? Anyway, ladies and gentlemen, please note that I am not aware of all of your rules. However, I am aware of the following: that the court has a bar and that these officers are presumably registered under such a bar. Purportedly, as officers of the court, they are the court's responsibility. Whether they act under the capacity of either a police officer or an attorney or a clerk's deputy, as the former, the former would be the police officers and the attorneys. So as the former group are executive branch jurisdiction, yet somehow the court has sidestepped the separation of powers prohibition and united with the executive branch against the people. Then we have, I gotta separate my comma right there. I'm sorry, there's supposed to be separation. Like Avant said, separate. Oh, I am a lion down in the jungle. Oh, I'm sorry. They are still said to be officers of the court. Doesn't matter if they're police officers, if they're bailiffs or police officers, if they're attorneys, if they're detectives, doesn't matter. They're all said to be officers of the court. The clerk of the court is said to be an officer of the court. Well, you don't understand because most people don't do the research. The Attorney General is under the executive branch of government. The Attorney General is under the executive branch of government. All attorneys are registered under the Attorney General's office. That's where they get their office authority from. It's not the Bar Association that gives them authority. It's the Attorney General that gives them the authority. That's why attorneys are registered. They're not licensed. They're registered. Okay? The Bar Association exists as a result of the Attorney General's office, not as a result of the court, which is regulated by the Secretary of State for the United States and for the state. It's an executive branch office, people. Well, under separation of powers, the court, pay attention, cannot combine, join, and or side with another branch of government. Separation of powers means separation of powers. So when they make these officers of the court, they have violated the separation of powers clause. Now it says they are still said to be officers of the court, i.e. the court's responsibility. So as long as you made these idiots officers, now you're responsible for all officers of the court. So don't sit up here and say, oh, well, that's this branch, that's this office. Nope, They're officers of the court. They're the court's responsibility. So don't send me back to no administrative branch of government. You made them officers, you're responsible for them. And when a member of the public, of the people or of the public, two different groups, ladies and gentlemen, the member of the people and a member of the public are two different groups. You need to recognize that. Don't think they're the same. When a member of the people or a member of the public claim injury, the matter must be given due attention, and no government agent, quasi-corporation, officer, official, and or representative and or public servant has immunity under such circumstances. At least that is the alleged intent of the people when ordaining government, was it not? To be immune from such injuries, as that is the limitations clause embedded in the Constitution. Now, what I'm going to do, what we do is, I knew this when I put this together, this sentence, because this sentence would be confusing to the idiots. No, I ain't talking about y'all. I talk about y'all when y'all not around. Y'all around right now, so I can't talk about y'all now because y'all around while I'm doing the video. Sorry. I don't have the ability of pausing this like you think. This is my phablet, and so I'd have to go through too many steps, and I don't feel like going through those steps. And we're going to get rid of this comma. Tick tock tick. Hey, you know that I'm dreaming? Okay. Now, we're going to go back to the last paragraph that I was on, that I was working with, because that was my friend. Let's see. District, okay. Where, belief, the presumption. Okay. Here's the next part that I think you all should be understanding, and then we're going to go ahead and end this video. I'm just letting you guys know what I've been working on. And when I say that I have been literally trying to prepare and work on this since 8:30 this morning, actually since 8 o'clock, but you know, who's counting? This is a presumption that I may or may not have been missing or lost at sea, or that I may or may not be competent to speak on my own behalf, or that I may be either an infant, a minor, a juvenile, or a person who has not attained the age of the majority. This presumption is not based on any facts, but on supposition. That presumption of law does not violate the Constitution of the United States Bill of Rights. A presumption in the form of the Americans' jurisprudence, the system of justice in America, is in violation of due process, and that a presumption is not based on facts or conclusions of law, and therefore denies a person their, that's the wrong there, y'all. Uh-oh. Get over there. In my eye. It's for real, y'all, because am I dreaming? Am I dreaming? Yeah. All right. A party their right to due process, to be free from accusation without proof in support of such accusation. Remember, the Fifth and the Fourth Amendment gives you the right to be free of accusations. Anybody can make an accusation, but they must prove their accusations. They can't just sit up there and make accusations just to be making accusations, like PennyMac is attempting to do. Don't worry about it. We'll take care of them in our due time. Okay, let's continue. As prescribed by the Fifth Amendment of the Bill of Rights in a probable cause clause. Let me make sure I finish that sentence. Probable cause clause of that same set of principled, secured obligational directives upon the judiciary. You see, remember, no warrant shall issue without probable cause. You are to be secure in your person, your effects, your property, and your papers. No one can seize your rights, people. Nobody can take your rights from you without due process of law. What's happening is that I don't think very many people have broken down the Bill of Rights and what they actually mean. Look at the First Amendment. Everybody thought it was Congress shall make no law which only prohibits certain rights. No, Congress shall make no law. Why? Because if Congress made a law without the consent of the people, it would be abridging the people's right to freedom of speech. Remember, Congress is supposed to be representatives of the people. They don't get to use their own mind. Congress is supposed to be doing what is the will of the people. So don't let them tell you that they get to do whatever they want to do and we have to follow what they have to tell us to do. Oh, by the way, before I go on, someone sent me, Willie sent me something about landlords and about how landlords are complaining that Biden saying we're putting a moratorium through the CDC. Well, the CDC did this under Trump too, okay? But they want to blame Biden for it because he continues it. Ladies and gentlemen, landlords not receiving payments from their clients, from their renters, so long as the government has made it to where they are not essential and that they can't travel to and from work, you can't kick them out of their home. Why? Because government is to blame. So what the citizens, the people need to be doing is suing government. What the landlords need to be doing is suing government for their monies. It's not the people that's the problem. The government has restricted the people from going to work. It is the government that's responsible, not your tenants. Now, hold on. They're saying that the government does not have the ability, does not have the authority, does not have the right to sit up there and limit people from collecting rents or from evicting people. Well, actually, they do. Don't you understand the very fact that you get to rent your property to someone and to engage in commerce in doing so? You are engaging in income and commerce by renting out your property. You're engaging in commerce. Government gets to regulate that. So don't let nobody sit up here and tell you that they ain't got no control. The Supreme Court say they ain't got no control. The Supreme Court just said government didn't have the authority to do that. That is a lie. Government gets to set the regulations on commerce. They said without going to Congress. That's why they said without going to Congress. It's the executive branch. The executive branch under the Administrative Procedures Act, since all of these people who are renting these apartments are doing so under state regulations, which is regulated not by Congress, but by the administrative branch, the Secretary of State. You don't believe me? Go back and look. I used to run apartments. All of the paperwork comes from the state. Yes, they can regulate. And yes, you agreed to be bound by their regulations because you chose to engage in commerce. So the people need to be suing government, holding government responsible, not only because you can't pay rent, because you can't pay rent because of government, because government imposed the restrictions. Government sitting up here talking about we gonna make and create $3 trillion, $85 billion. Well, instead of just creating that, why didn't you just pay off the mortgages? It wouldn't have even have cost you that much. And you still could have given the people. Why didn't you just pay off the mortgages for 5 years? Given a 5-year moratorium on mortgages and paid off the landlords. But paid off the landlords not in one lump sum, in monthlies. The same as the tenant would be required to pay monthly, the same as the mortgager would be required to pay monthly. Then why not do it monthly? Pay them for 5 years monthly so that nobody's short on nothing. And then you do 5% increases yearly. Why? Because they get to increase the mortgage. And once the moratorium is over, then you bring down that 5% because it's a 5% per year, which in 5 years, pay attention, 5 times 5 is 25. Their rent would have gone up 25%. No, you bring it back down to the original. Why? That seemed like that. That's the benefit of letting government come in and help you out. Mortgagers and mortgagees and renters and rentees. I know you should run for president. I ain't running for nothing. Sorry, I'm using this stupid app. What is the name of this stupid app? This is iHeart, and I got a modified version, but they figured out a way around the modified version to have their little pop-ups, and it just caused me so much pain, and I don't know what to do. That's okay. I'm gonna be taking care of iHeart because iHeart is getting on my nerves anyway, and I ain't liked iHeart for quite some time. I liked it at first, but I don't like it no more. All right, anyway, got some real music in the background again. So, ladies and gentlemen, that's my comment on this whole mortgage thing. Yeah. I know. When I told you in a 4-year period, 4 law firms, pay attention, 3 in Puerto Rico, asked me to come be a consultant. Why? Because they don't think like I do. They don't break things down like I do. They don't come from the hippity hip like I do. Hippity hip, hippity hop. Okay? But I come from there. Okay? No, we ain't playing this song again. I just heard that song. Ooh! Sorry. There's the miracles, y'all. All right, let me continue. Ladies and gentlemen, I want you to pay attention to this because like I brought out the point about the high crimes and misdemeanors, again, it is logical, it fits, and nobody can argue it. When they talk about Congress did not define, yes, they did. They defined it in the law. High crimes and misdemeanors falls under crimes. Both of them are crimes. A higher crime is known as a felony. I've already told you, a judge violates his oath of office when he commits a felony. The courts have said, well, no, because it doesn't say that. Yes, it does, you ignorant mother. I'm sorry. Because judges' jobs are to figure out and find ways around things and out of things. And if you look at most of their logic is stupid because they know most of you guys don't do law. Even though ignorance of law is no excuse. So as long as you don't rebut their presumption, which is why I'm saying presumption of law is against the law. The courts are not supposed to be going off presumption. They're supposed to be going by the law. So how come these idiots ain't going by the law? They're not going by the law because in their mind they don't have to. Let me finish. And while acting under the purported presumptive law, the courts lack jurisdiction over my person, over the subject matter, and over the venue for which the matter was presented to court in the first instance. I, supposed to be not does, because I changed the sentence. I does hereby, I can leave it like that if y'all won't. I do hereby bring forth my claim that the reported judicial branch of government has violated my due process rights. Don't worry about it. All judicials, all courts, all judges will all be capitalized. All states will all be capitalized. See, what you guys don't understand is that the government and Microsoft got together and all these other companies got together and they made sure that if you use things like voice recognition, that it doesn't capitalize proper nouns like state, like government, like jurisdiction, like judges, like judicial officers. It doesn't capitalize that. You have to specifically, like I did this, it said judicial branch. It did not capitalize it. And because it did not capitalize it, I have to make it capitalize it. You follow me, Vern? And that's the problem. Oh well, life goes on. And when it goes on, it gets there and it keeps going and going and going and it don't stop till it get enough. Don't stop till you get enough. Now this is Angie Stone and she's singing More Than a Woman, y'all. That's Angie, y'all. Well, anyway, let me continue, shall I? I do hereby bring forth my claim of reported judicial that the reported judicial branch of government has violated my due process right, subjected my person. That 2 ain't supposed to be there. That's supposed to be the T2. T2, like D2? That's right. Person to deprivation of secured rights, to a denial of my right to property, to a denial of my right to pursue happiness. I got a right to be in pursuit of happiness. Get out of my way, Will Smith. To a denial of my right to due process of law as expressed in the Bill of Rights. The presumption that somehow I have accepted the benefits and privileges of the 14th Amendment, Section 1 are unfounded. That R is supposed to be separated. So we're going to separate it by... You know what? I think this is Music Soul Child, if I'm not mistaken. No, this is Calvin Richardson. Sorry. Had to look at it again. Sister, my brother, you're more than a woman to me. Anyway, ladies and gentlemen, and not supported by any substantive facts and or law, nor have I ever willingly, knowingly, or intentionally and explicitly consented to be subjugated by such servitude. My right, which are my property. Your rights are your property, people. They're your possessions. No one can deprive you of your possessions without just compensation and due process of law. They claim that the privileges and immunities of the 14th Amendment is just compensation for your rights. Please? They're just compensation when you deprive me of my rights? I don't think so. And you don't give me due process? You must be out of your... I'm sorry. Okay. Which I own and possess have been seized, taken from me, subjugated. Subjugated. I said subjugated when I said was supposed to be subjected earlier, but subjugated by public servants. Well, you know, the reason why I put subjugated by public servants and I highlight public servants, because they're public servants. A servant doesn't have the right to subjugate the master. Subjugate. I said subjugate, but subjugate. all of the unjust, all to the unjust enrichment and financial gain. Let's do this right here. All to their unjust enrichment and financial gain through mechanisms not limited to the trading of bonds and other securities on the market. Taking a case and or a case number and or a case file. That O is a program issue with Google. It does that all the time and I don't know why, and eventually I'll do some research to figure out how to stop it from doing O, because I have to remove that like 10, 12 times. Anyway, and creating a security out of such documentation is not uncommon. For securities creation is not difficult, especially when you have individuals who are versed in such activities, and or so it is believed. Again, it is believed, it is based on my personal belief. Stick with your beliefs, people. Always say, I believe that the law does not allow you to do this. I believe that you're violating my rights and that you're discriminating against me. You know what I believe? I believe that you ain't no judge. And I believe that you can't prove that you're a judge and that you're sitting in a judicial capacity at this time. That's what I believe. Now prove me wrong if you got the ball, to do so. You know what I'm saying? Anyway, I am relatively aware that the judicial branch can either, this is supposed to be neither, not either, can neither establish nor make law, as that authority has by tradition been reserved for the people, not Congress. Congress does not get to make the law. The people get to make the law, and Congress enacts the law. Okay, based on a consensus. Well, Congress has this thing where they make bills. They can make a bill all day long. That bill ain't no law. The people. That's why California has the proposition thing, where they make propositions, and they're propositions when they make it. You know what I'm saying, Vern? When they make their propositions, that's how that works. Uh-oh, I messed up. I hit the wrong button because I'm still playing my music. I'm just getting around the commercials because I got an app and it says commercial free. It ain't commercial free, y'all. And I just wish it was. And so what I'm going to do is I'm going to talk about some love and happiness, because something that make you do wrong and then it make you do right. And then y'all know what I'm talking about. Yay! See what I'm saying? That's Al Green, y'all. Love. Al Green, y'all. All right. So, ladies and gentlemen, it says, who then directs Congress to enact such a provision and or provisions into what is referred to as the law of the land under common law authority. See, it's the common law that gives the people the right to enact laws that benefit the common community. But they do so under the way the United States is set up, through Congress. Now, through Congress, the people do it through Congress. Have you noticed that the people are not the ones initiating these laws that Congress keeps coming up with? It is congressional members who do it, claiming that they're doing it on behalf of their constituents? No. The reason why California does the proposition is so that the people can vote on it. And we all know it's not a perfect system. I can't stand the system. That's why I don't vote, people. I don't vote because I'm not part of this world. I don't want to have nothing to do with this world. But everybody else, if you don't get out to vote, and if you don't vote, you don't have a... Please, I have every bit of a right to have a voice as anybody else and their grandfather. And ain't nobody said I have to vote. Go ahead and look at the Constitution. Sorry, there was a bug on me. This is the bug capital of the world. And he ain't supposed to be touching me. I have a rule. Don't touch me. You're going to die. And he died. Sorry. Just the way it is. All right. Your mama. Okay. Who then directs Congress to enact such a provision and or provisions into what is referred to as law? The law of the land, common authority. The First Amendment prohibition against Congress making laws that obliges the rights of the people. One of those rights the people have is that of making laws. Congress doesn't make the law, people. It's only been presumed by this statement in the Constitution that Congress makes the law. It was not the intent of the people that Congress made the law, because then that's another body ruling over you. The people never would have accepted that. Okay? The people never consented for Congress making the law. Congress were to act as representatives of the people and were to do what the will of the people were. Okay, let me continue. To make no law clause prohibits that body, the judicial branch, and the legislative branch, and the executive branch. See, I put the judicial branch, the legislative branch, even though Congress is the legislative branch, so I'm still putting it there, and the executive branch from making any law that would infringe upon the common law rights established by the Bill of Rights of the Common Law Constitution of America. It is my belief that ignorance of law is not excusable. So there is no apparent reason for anyone in any position of government to not know the aforementioned facts of law. There is no excuse. It's called judicial notice. Judicial knowledge, sorry. Everybody keeps misunderstanding what's going on here. These idiots are already supposed to know these things. I'm not making this up. I'm not imagining this. I am not bringing this together. I am telling you, all you got to do is read the Bill of Rights. Don't go by what somebody told you it means. Why would you do that? No, go by what it actually says. Go by what it actually says. The 7th Amendment restores to everybody the knowledge that we are supposed to be under what? Common law. That's how we're supposed to be. But we are not. Oh, you know what? I messed up. I messed up. I'm sitting up here playing around with the music in the background, and there is something that I'm supposed to be doing. And when I say I messed up, because I went about it the wrong way, and now I'm going by it the right way. So I apologize to y'all, because now I know what I was doing. Before I didn't know what I was doing, because, not knowing what you're doing is easy, because that's what everybody else gets to do. So I was trying to be like everybody else. But you can't be like everybody else, because everybody else don't want you to be like everybody else. They want you to be like them. Nobody wants to be like them. Who's this? This the barge? Nah. Brick House? Nah, we ain't playing Brick House today. Give me a second. It's written in the stars. It's written in the stars. Y'all better believe we gonna play It's Written in the Stars. But this is gonna be John Legend. All right. Ladies and gentlemen, I am further aware that the legislative branch does not have the authority to invent or create judges, that the Constitution does not give such authority and or permission to the legislature and or the executive branch of government, only the judicial branch. Go back and look at the Constitution and see, where did Congress get the authority to establish the judicial branch? Go ahead. No. I am letting you know. They got the authority because they presume that the Congress shall make no law. Congress shall make no law gave them the authority to make law. It's not what the original so-called forefathers believed. They just took the instrument and they started interpreting. Ladies and gentlemen, that's the problem, because you're not supposed to be allowed to interpret law. Go ahead. But people do it all the time. For instance, there are a lot of people who attempt to interpret the Bible. Can't interpret the Bible. The Bible is backed up by itself. It doesn't need you to back it up. Doesn't need your opinion. Doesn't even need your input. So the Constitution, when the Bill of Rights was written, it didn't need nobody else's input. Yes, it was incomplete, but it was solidified by those rules that were established at the very beginning. All right, now look, I'm not going to go on and on and on, because I could. Oh, you just know so much? No, I don't know so anything. What I do know is that what they've been doing is they've been playing around with this instrument. Go back and look at the First Amendment. Congress shall make no law. Well, Congress only had the authority to make law at the will of the people. They were representatives of the people. They are not the authority. Everybody keeps thinking that government has authority. They only have delegated authority. It's called the delegation of authority. So they are not your rulers under the United States form of governance. I'm not saying anything wrong. I am saying things that they don't like because they know these things. The courts were never supposed to be making rulings because the courts don't rule over no one. Go ahead and see what amendment in the Constitution gives the court to rule, gives the court permission to rule over you. So then, why are they making rulings? They can make judgments, they can give their opinion, but why are they making rulings? They don't get to rule, people. That's the whole premise of the government that they set up in the United States, was that no one got to rule. They were just leaving the fact of a king, a tyrant, was ruling over them in England. So much that they had a revolution and a war to prevent someone from ruling over them. That's why it speaks about them being free. You can't be free when you have a ruler. Go ahead, just sit back and think about it. Go back and think about it. If you have a ruler, that makes you a servant. You cannot be free if you're a servant. I was free. Oh, these chains, they ain't really here. No, them not. I'm free in my mind. Yeah, that makes a lot of sense. All right, ladies and gentlemen, this is just me saying to you, you have the right, everyone. Y'all can think for yourselves. Y'all know how to think for yourselves. Y'all know when to think for yourselves. I don't know why y'all don't think for yourselves. It's kind of disheartening when y'all don't sit up here and try to make them do what y'all need them to do. Y'all make me do what y'all need me to do, so why y'all not making government do what y'all need them to do? Got me sitting up here working day and night. I don't know, because I'm so tired, but you got me working day and night. And that don't make no sense. I don't understand it, y'all. I really don't. Okay. With that being said, everyone, this is the judicial complaint document that we're working on. It's going to make these quote-unquote statements because you're bringing forth a complaint. In a complaint, you do have to state the who, what, when, whys, and wheres. So now I have to add that section. That's what I'll be doing today. This will probably take almost another week to complete. Why? Because it's not a simple document. Because it hasn't been done like this before. Ladies and gentlemen, when you file your complaint with the court, don't they provide you the form? Why? Aren't you allowed to create your own? So we're going to create our own. We're going to keep it short. We're going to state facts. We're not going to state opinions. We're going to state what we believe. And some of you are going to amend it and you're going to make it say all kind of stupid things. That's right, you heard me. I used the word stupid because that's what it will amount to. Stupid. Stupid is what stupid does. Forrest Gump, mama always said it. Box of chocolates and everything. So some of you are going to be doing a lot of stupid things, just like some of you killed your own contracts. Ladies and gentlemen, I did a video the other day documenting to all of you how valuable the contracts were and how valuable they continue to be. What I did not do to the document is I did not add the thing about the arbitrator being the only one to determine the value of the contract, to determine whether or not the contract is valid or not. See, the courts are going off of old, outdated cases that the Supreme Court has continuously said if the contract, that's why they did what they did in Archer. They solidified it. If the contract says that an arbitrator is to make the determination, the courts cannot interfere. That's what the Supreme Court said in Archer. There's this thing called severability, separation of the arbitration clause from the rest of the contract. What has to be determined first is whether or not the arbitration clause is valid. The court wants to determine if the contract is valid. So that's why Archer was so important. Archer says that, hold on now, if the contract has an arbitration clause, well, the party to determine whether or not the contract is valid is not the court, but it is the arbitrator. If the parties have elected to have the arbitrator be the final adjudicator of whether or not the contract is valid or not, and to have exclusive jurisdiction, the courts cannot interfere. But they're interfering. Why do you think we're creating this complaint for everybody? I told everybody to get grandfathered in. They will be changing things, I promise you. They'll have no other choice. Because the contracts is what takes away their power. And that's what they don't like. Nobody likes their power being taken away. No one. Trust me, I don't like my power being taken away. And all you people up there in Michigan, y'all didn't like y'all power being taken away. And so they gonna be bucking heads because their power's been taken away. So guess what we did? We showed you how to write off that debt by doing 1099-Cs and receiving a credit from that debt. Then we showed you how with us, how the IRS charged us interest on the debt that we wrote off because they constituted that debt as income. I don't know why people don't understand the value of arbitration and arbitration contracts. Some of you did. I know some of you are saying to the screen right now, I knew it. I knew it. That's why I did the arbitration. Okay, look, we're going to let you know. Just because you do arbitration, that's not a guarantee that it will go your way. So the only thing is the default. But eventually they're going to catch on. They're going to start responding to your claims. They're going to start responding to your paperwork. They're going to start looking at the contract and finding a way in order to stay in honor. So do yourself a favor. Before they do that, send your contracts out, people. Get them in default. They're going to use this against you, EON. You telling people to get people in default. You better believe it, because if they have a duty to respond, we just showed you the case law. If they have a duty to respond and they don't respond, and if they have a prior relationship with you, they have a duty to respond. Go back and look at the document we put online. The one that talks about duty to respond. That's the title of the document. Just go to the PDF section, type it in, do a search for it. Duty to respond. It's in several folders, so you can't miss it. The same document. The next one was going to be the arbitrator. The arbitrator has the power. That's what we're going to say, because the parties to the contract gives the arbitrator the power. Okay? Now, ladies and gentlemen, they're going to say that's the same with Congress. If the parties can give arbitrators the authority over them, no, over the individuals, not over the whole nation. You see, in order for the government to have authority to rule over the whole nation, all of the people, remember, the people individually, because we're talking about individual rights. We're not talking about collective rights. Arbitration deals with individual rights. The parties have to agree. And when the parties agree, then that becomes a valid agreement. But most people don't understand it. Why? Because they don't get it. They don't understand it because they don't get it, and they don't get it because they don't understand it. And I can't, it's not my job to help explain everything to y'all. Y'all are supposed to know the law. Y'all are supposed to know the law. And y'all don't know the law. And it's a shame. Now, we're going to end this video with R. Kelly and him believing in something. I know he believes he wish he could right now, huh? I'm kidding. I've been in his shoes. I've been where he is. I've been inside. And I have a lot of people that I communicate with who are still inside. I was just reading about Anthony White. If you haven't heard the Anthony White story, go ahead and YouTube it. Anthony White, 20-some years in jail because some police officer said that he did something. And then they planted evidence. How in the world could this happen? That they planted evidence, and that man has been declaring his innocence all that time, and nobody would help. He's not the only one. Ladies and gentlemen, there are so many people throughout the United States whom the evidence shows that they are innocent, and they're still in jail because the courts are doing technicalities. Well, you don't get to violate somebody's rights, which is why the incarceration contract exists. Okay? And so what? They said no. They dismissed my contract. That's why you're going to go back in and you're going to file a complaint. But they dismissed my whole arbitration. They said it was bogus. Okay, let them say that. Still doesn't mean that there's not a debt. You've already established the debt. You've already established the record that they received the contract. So as long as there's a valid, pay attention to the word, valid debt, the courts don't get to make that determination that there is no debt, that they don't owe you anything, and they pay attention to their orders. They have not at any point and at any time said that they don't owe you anything. They have not at any point and any time said that there was no debt between you and the other party, because they can't. Why? Because that's your common law right of set off. Can't nobody interfere with that. And you establish that by sending out the documents. But for those of you who want the tax credits, pay attention. You're going to have an arbitration award to support the tax credits, because the arbitrator has the authority to issue an award. Just having documents, arbitrator needs to prove that the parties had an obligation. So as we told you, give me a couple of days, because I'm working on a couple of things, but I'm going to redo the plus pack to make it without the benefit of the arbitration, the discount of the arbitration. We're going to make it without that discount, and so it will be a lot less, and that way you'll be able to have your contract and you'll be able to have your default. And when worst come to worst, because look, some of you, I'm sorry, as many videos as I put up, many of you just are not capable of doing it. Look, ladies and gentlemen, I have solar panels to hook up, and I have the electric for the solar panels to hook up, and I haven't done anything yet. I've only ran the wire, did the underground, put the wire through the tube, ran it underground, because I don't want the ground squirrels to eat up the wires. And so I've already done that and completed that. Here's the problem. I haven't done anything else. And there are reasons for it, but here's the thing. The main reason was I didn't want to make a mistake. I didn't want to burn anything up, because that's expensive. So watch this. It turns out that it ain't as expensive as I thought, because I already have all the components, with the exception, I sent back an inverter, and I said I'll get the inverter when I need it. Well, I thought I'd already gotten it. I thought I already had it here, and I didn't have it. So I just had to reorder the inverter, and my solar panels should be up momentarily, and I should not be using the generator as much. But this is me saying I understand what it is to be afraid to do something because you don't think you know everything. Okay, and you don't know where to go get the research. I assure you, I've talked about arbitration from A to Z. All you got to do is go to the EEON channel and type in arbitration, or whatever subject it is, type it in the EEON channel and see if it comes up, because I'm very specific about how I word certain videos. And remember, as I said, my videos follow succession. One talks about the other, and they go one after the other. So while me and R. Kelly, we go and we fly, if I just spread my wings, I can fly. Woo! Me and R. Kelly. All right, ladies and gentlemen, y'all have a good day. I gotta go because I got work to do. Y'all know the type of work I'm doing, right? So let me do my work. Bye.